translation from English to Spanish. Give people another 2 minutes or so. We're going to start in about 1 minute. For those that have joined, thank you very much for joining on time. We're just going to give others a minute or two to join, and we'll kick off. All right. So I think we're going to go ahead and get started. Thank you again for everybody for taking the time to join today. I really appreciate the opportunity to present. Just a couple of preliminary comments. First, for those that are joining and would like to take advantage of the simultaneous translation into Spanish, please remember to click on the button at the bottom of the screen that says interpretation, and that will give you access to simultaneous translation from English to Spanish. So let's go ahead and get started. My name is Jeff Lateman. I'm joined by Maria Lapatina from the law firm of Miller and Chevalier in Washington, D.C. We're delighted to be here today, both as representatives from Miller and Chevalier, as well as the Compliance Latam platform, in which many of you may be aware. Miller and many other firms were founding members of the Compliance Latam platform, which is essentially a regional compliance platform to give space to people that are interested in cross-border compliance issues in the Latin American region as a space to share experiences and share thoughts. And the presentation here today is one of a continuing series of presentations in which we focus on relevant and timely issues to general counsels, compliance officers, and others in the region. If we can go ahead and share the presentation and put it up on the screen, that would be appreciated. While we're putting up the presentation for today, just a word about the format of today's event. We have styled this event as sort of an informal chat or discussion where we will be focusing on the updated memorandum that was issued recently by the Department of Justice that deals with the evaluation of corporate compliance programs. And we have intentionally formatted this as a conversation, and there'll be sort of back and forth conversation between Maria and myself. But that is intended to facilitate questions and discussion among those that are participating here today. We have a sufficiently small group that is joining us that I think enables us to be able to respond to questions in real time as they arise. So if you do have questions or you have comments that you would like to make throughout the presentation, please feel free to make those comments in the Q&A section or in the chat section at the bottom of the screen, and we'll do our best to answer those questions as we go through the presentation. So as I said, if we go to the next slide, as I said, the focus of today's event is on the updated memorandum that the Department of Justice issued earlier this year in March of 2023. For purposes of today's conversation, we're going to assume that most people that are joining the call have some basic knowledge of what the DOJ memorandum says and does. And so we're not going to go way back to the beginning and focus on each of the different components of the memo, but rather to focus on what is new in the memo itself, because there are two particular topics or two particular areas that I think have many people thinking and talking about how companies are going to try to achieve the standard that is set forth in the DOJ revised memo. But just briefly, as a review for those that are participating, what is the DOJ memo? The Department of Justice's memo on evaluation of compliance programs is a document that was first published in 2017. And since it was published by the Justice Department in 2017, it has been updated a couple of different times since then. And the most recent update, as I said earlier, was published in March of 2023 in this year. Essentially, when the Justice Department decided to put out or to issue their memorandum, it was really in response to a lot of criticism that existed in the market at the time. And that criticism came from both from the private sector, but also internally at the Justice Department, where prosecutors and others were really looking for more senior level guidance in terms of what they should be looking for in terms of evaluating a company's compliance program. For many, many years, the United States sentencing guidelines have essentially said that a prosecutor is required to, among other factors, to look at the effectiveness of a company's compliance program in determining whether to bring criminal charges against the company and to what extent to impose a monetary or criminal sanction against that company. So the framework for evaluating a company's compliance program has existed for many years. What was missing was the type of guidance that is nowadays reflected in the DOJ's memo. So even though the Department of Justice likes, prefers people not to refer to their memorandum as guidance per se, what has happened as a practical matter is that the memorandum published by DOJ, as it has been amended, has taken on more of a characteristic of being of serving as guidance, both to prosecutors within the Justice Department, but also to people within the private sector. Essentially, the memo is a 20-page document that outlines several components that the Justice Department expects to see in what they consider to be an effective compliance program. It is not mandatory for companies that are subject to DOJ jurisdiction, but it is a very, very strong suggestion, I would say. And so what has happened over the course of time, again, as the memo has been amended, the DOJ memo and the concepts reflected in that memo have started to take on an element of being considered international best practice or international best standards. And that is not to say that the DOJ has it right 100% of the time. And in fact, we'll talk about some areas today where the DOJ, I believe, has opened itself up to scrutiny from companies that are based outside of the United States. But I think it is fair to say that the elements or the components that are reflected in the DOJ memo have really taken on an element of being considered international best practices. So with that background, I think it makes sense for us to dive in and talk about sort of what are the most significant changes that we see in the March 2023 version of the memo. So Maria, do you want to walk us through what we consider to be the most significant changes?
Sure. And we can go to the next slide, please. So there are two areas where the DOJ added a lot of language and suggestion, to use Jeff's word, in the updated memorandum. And those two areas concern ephemeral messaging. So for example, the use of WhatsApp or WeChat or all those other channels where people are sending messages that could be encrypted and hard to save. and executive compensation. And this is an idea that sort of using compensation and clawing back compensation or giving extra bonuses to incentivize compliance or to punish those who have violated the compliance policies and programs. Both of these ideas have sort of been marinating for a while, and we'll talk a little bit about the history of sort of both topics and how they've sort of come to be hot topics for the DOJ. But in this most recent revision to the memorandum in March of 2023, we're seeing the DOJ actually write some very clear language about what they're expecting or what they're hoping to see, subject to a number of caveats, in these two spaces. So those are the two areas that we're going to focus on today. Just one thing that we wanted to note, this is obviously very new guidance. It's only been in place, and it's not guidance, the very new memorandum, only been in place for about 3 months. And so we don't yet have the benefit of the DOJ reacting to compliance programs. We haven't seen sort of new resolutions or the DOJ saying this works, this is what we want, or this isn't what we want. It's all still sort of evolving. And so as practitioners around the world, I think everyone is still sort of grappling with this new language and these new provisions in the memorandum, and thinking about how best to implement them and what it really means and how it can be implemented in practice. So I think that's important to keep in mind, because this is sort of evolving. It's an evolution. We're still working through sort of these new bits. The other thing that we wanted to note at the outset, and this is very important, I think, particularly for this group of practitioners working outside of the US or in this cross-border capacity, is that the DOJ does recognize that we, and this group, is dealing with local laws that might, in some places, be in tension with this new memorandum or the updated memorandum. And the DOJ has said in a couple of different ways, both through this memorandum and in public speeches, that it recognizes that struggle, that it recognizes that there are local laws and foreign laws that might make it difficult in some instances to implement some of these suggestions in the updated memorandum. But what I think we're starting to see, and what I think the DOJ has made fairly clear, is that it's not enough to simply say, okay, there are foreign laws that prohibit this, there are privacy laws, and therefore we can't retain this data. The DOJ, I think, at this point is starting to really probe and say, okay, well, what drove that decision? What makes it difficult for you to do X, Y, and Z? Or why is your program set up in this way? Tell us about your interpretation of the local laws that drove this decision. So I think that's important for us to keep in mind, because while there's sort of two sides to that coin. There's the recognition that local laws can influence and affect how we're setting up programs and how we're addressing things like ephemeral messaging and executive compensation. But the analysis still has to be there, and it needs to be a thorough analysis to be able to say, okay, this is what the local laws are requiring, and this is why we can't do this, or this is how we're sort of reconciling the DOJ memo with our local requirements under local law.
So Maria, of those two sort of substantive areas that are treated in the revised memo, I think the one that's the hottest of the hot that's being debated is that relates to ephemeral messaging. People say ephemeral messaging. For purposes of this crowd, I'll just call it WhatsApp, given the sort of ubiquity and commonplace nature of WhatsApp among communications in Latin America in particular. So can you give us sort of a little bit of a historical view on how we got to where we are today with the DOJ focusing on this type of messaging in the memo?
Sure. Yes. And can we please switch to the next slide? And the one after that. So ephemeral messaging has been one of those topics that's been sort of marinating for some time. And about over a year ago, the SEC first brought a case against JP Morgan. It was the first settlement in this space. And essentially, JP Morgan as a bank, as a financial institution in the United States, has, under the federal securities laws of the United States, record-keeping requirements. JP Morgan is required to maintain business communications. And that was, and it wasn't doing that. And it wasn't doing that because employees at the bank were using applications like WhatsApp and personal email and text messages to talk about the business, but those communications weren't saved in the JP Morgan system. And they weren't, so JP Morgan wasn't able to capture them, wasn't able to share them with the DOJ and SEC when asked. And the SEC found that as a result, JP Morgan had violated those federal securities laws, those federal record-keeping securities laws. That was the first case that came out in December of 2021. And then shortly thereafter, in September of 2022, I think there were 16 banks that found themselves in similar situations with similar settlement agreements with the SEC and also with the CFTC. So it was the same situation where these banks were being penalized by these agencies for failure to preserve these messages. And it was the same type of messages, the WhatsApps, the texts, the personal emails that weren't captured on the bank system. It was very expensive for these banks. There were very large fines that were imposed, and the banks were also required to engage a compliance consultant to help look at their policies and look at the infrastructure to make sure that those messages were preserved going forward. We understand that there will very likely be additional waves of settlements that emerge. So we've seen sort of one tiny wave with JP Morgan, and then we saw a larger wave in September of 2022, and we fully expect that there will be more banks that are in the same situation. And again, this is born from their federal laws requiring them to maintain these records. So this is sort of historically how we first started to hear a little bit about ephemeral messaging and what the SEC and CFTC were requiring. And again, it was tied to these specific set of laws for banks. The DOJ has now included similar language in its memorandum for corporate compliance programs. So what we're seeing is that the expectation to preserve these types of messages on WhatsApp, on WeChat, etc., is no longer limited to financial institutions. The DOJ is expecting now all sorts of companies that are within its jurisdiction and that have corporate compliance programs to have some steps in place to be able to preserve these communications. It's a little bit different because these other companies that are not financial institutions don't have that legal requirement to record and preserve these messages. So it's positioned a little bit differently than the banks in this situation, but you start to see sort of the genesis. There's, for so long we were focused on emails, and now all that email traffic has been moving to these other applications, and the banks were the first wave to be penalized for not capturing that data. And now we're starting to see that those same standards are going to apply to other industries and to other companies.
Maria, if I'm not a bank that's subject to the U.S. securities laws, right? But I'm a company that is based in Latin America, and maybe my shares are traded in the United States, or maybe I have operations in the United States, and I see that there's this new language in the DOJ memo. What are my incentives to actually take some steps in response to this? Why should I be incentivized to actually listen or take heed to some of the language in the memo?
I think that's a really important question, especially for this audience. And we just ask that we switch to the next slide so we can talk about two of the primary reasons why a company that doesn't have those legal requirements might choose to follow this suggestion in the DOJ memo. The first, and I think this is probably the most applicable, is that the DOJ, when it's talking to a company, when the company is in a situation of potential wrongdoing or potentially negotiating a settlement with the DOJ, there are two steps that the company must take. First, a company often in that situation is cooperating with the DOJ. Cooperation in the United States is very valuable. It can result in some leniency, a smaller fine, a better resolution for the company. And so we start with the cooperation context and what's required in the cooperation context. And what's becoming clear is that if you're cooperating with a DOJ investigation, if you're in that cooperative posture, you're going to need to produce documents, not just emails, not just financial records, but now the DOJ is going to start really wanting to see the third-party applications, the third-party messaging like WhatsApp or like other texting applications. So in that cooperative posture, it's really important to be able to show full cooperation, and full cooperation now will include, I think, going forward, this data, these types of communications. I do want to mention, that the DOJ has recognized the local law considerations, but here is a perfect example of a place where the DOJ might probe. A company operating outside of the United States might say, it's really hard for us to capture that data. There are data privacy considerations or other local laws at play that make it really difficult for us to capture that information and to produce it to you all in the United States. And I think that's where prosecutors are going to be in that position of saying, okay, we need to probe. We understand that premise, but we want to understand how we got there. And it may be that at the end of the day, the local laws like do prevail. But that's a perfect example of where the DOJ, I think, is going to start probing a little bit more and kind of looking a little bit deeper to see really why it's difficult for a company to cooperate fully by providing those third-party applications.
Thanks, Maria. If I can ask, I think we're a slide or two behind. If we can move the slide forward. And Maria, I think with that context, I see we have one question, and we'll come to that question in a second. Can you speak a little bit more specifically to what does the DOJ memo say in terms of expectations of companies with respect to ephemeral messaging?
So I think, and sorry, I think we're still a couple slides behind. If we could keep moving forward. Yeah. Okay.
One more, please.
Okay. Just briefly, I wanted to mention, so we talked about cooperation, and I also wanted to mention that a second reason for a company operating outside of the United States to think about ephemeral messaging is because now, as this memorandum makes clear, capturing and preserving and maintaining those messages is now considered one of the factors to consider when evaluating the compliance program. So for a company that is in a situation where they're talking to the DOJ, there's potential wrongdoing, the DOJ is going to consider a number of different factors. One is the fullness of the cooperation, but another one that's really important is how strong the compliance program is, how effective is it, and how does it work? And now the DOJ is saying ephemeral messaging and capturing that messaging and preserving that messaging is part of your effective compliance program. If you don't have that, that's sort of something that we'll consider when looking at your compliance program and how it works. So those are the two main reasons why a company, particularly those operating outside of the United States, might still be interested in ensuring that those messages are being captured, because it affects both the cooperation in this dialogue with the DOJ and also the evaluation of the compliance program. Okay, and now I'll catch up. I'm a question behind, so let me catch up a little bit. So what is the DOJ, as Jeff just asked, what does the DOJ want to see? What's the expectation? And I think this is something, what the DOJ has said is that they want to see company policies and they want to see the compliance program respond to the company's risk profile and respond to the company's operations. And in order to, or with the goal of preserving business-related electronic data and communications. So what that means, and I think this is consistent with sort of the DOJ's approach more generally, is this isn't a one-size-fits-all type of scenario. There isn't one golden policy that will work perfectly for every single company or for every single industry. Just as the DOJ has said in the past, these policies really need to respond and be tailored to the company, how the company works, how the company operates, the sort of the infrastructure of the company. And these policies really need to make sense for the company. And that's the only way that they really work. And so in the same way that when we're looking at other policies and procedures in the company and always trying to make sure that they're responsive to the risk profile of the company, in this space too, that same kind of rule of thumb applies, that the policies around ephemeral messaging and preserving this kind of data needs to make sense in light of the company's risk profile and the way that it works.
Maria, let's take a second to respond to one of the questions that's been raised. And I think the gist of the question is, how do we expect that enforcement of some of these new standards in the DOJ memo will take place? So do we anticipate that enforcement will be proactive by the DOJ on this, in the same vein that the SEC kind of proactively enforced messaging retention against banks? Or do we expect this issue to really be folded within or asked about in the context of other, other investigations that may be launched by DOJ, or investigations that are launched by a company voluntarily disclosing an issue to the DOJ?
Do you want to take a
Go ahead.
stab first? So my prediction at this point would be the latter, that enforcement would be sort of folded. This will be folded into ongoing enforcement actions. The SEC's enforcement was very specific to banks, and it was tied to specific laws, right? Those federal record keeping laws. And so that was why, and I think that really is important context, because it shows the legal basis by which the SEC was able to bring those cases. I think what the DOJ is saying here, and the fact that it's in this memorandum in particular, it makes it a little bit different, right? It's not saying this is a legal requirement, you have to do this. It's saying this is part of a broader, more robust corporate compliance program. So we expect to see this, but this is going to be folded into our evaluation of your compliance programs, which is folded in into the broader context of an ongoing investigation.
And we have a second question that's come up that I'll translate from Spanish. It basically says, what are the risks and or penalties that companies face by not following the DOJ standards? And I think that's a little bit connected with what you were just saying, but I'll let you respond to that.
Sure. So the DOJ has published some other documents that are very helpful in this context, and they talk about how the DOJ evaluates a company in the criminal context. The company has engaged in wrongdoing, and the DOJ is looking at that company and saying, are we going to charge this company, or are we going to reach a deferred prosecution agreement with this company? Are we not going to do anything, decline to pursue this company? There are lots of different options. And when making that decision, when making those charging decisions, there are a couple of different things to consider. One, as we mentioned, is the cooperation. How were they cooperative, and how full was that cooperation? But another one of those factors among several is the corporate compliance program. So if the corporate compliance program isn't effective and it sort of gets a bad score, it is one of the factors that's considered when deciding how to charge the company and what the fines are going to be. So it's hard to say, if you don't have this program, then you're going to be fined this amount, because there are a number of factors that go into that decision. But having a strong corporate compliance program is always a benefit with the DOJ in reaching a resolution that's more favorable for the company. So,
and I think it's fair to say that now, with all of the attention that has been focused on WhatsApp and other messaging platforms, that in the context of those types of discussions with a company, DOJ is going to for sure expect that a company has spent time thinking about what they have in place, what are their policies and procedures, and how are those policies and procedures enforced, as part of trying to evaluate whether a company is really cooperating. And so, the way in which DOJ investigations work, typically DOJ will expect a company that's cooperating to provide all relevant documentation, all relevant documents, emails, and other materials that are relevant to a particular investigation. And DOJ will and does ask about other types of messaging, WhatsApp messages, text messages. And if a company is in a position of saying, well, we don't collect those, we don't preserve those, we have lots of people who operate around the world and use WhatsApp in the ordinary course of their business, but we don't have any way to actually give comfort to DOJ that either people don't use those messaging platforms for business communications or that we don't have any way of preserving them. DOJ is going to view that as a strike against or as a negative effect on the company's cooperation. And as a result, the company is less likely to be able to negotiate a beneficial resolution with the government. And I think what that leads us to, Maria, is, given where we are today, given that the guidance in this memo has taken on such importance, and companies' compliance programs have really been geared towards satisfying the DOJ standards. What do you suggest companies do as a practical matter to try to respond to the ephemeral messaging aspects that are in the DOJ memo?
Sure. And if we could move to the next slide, or we might be one or two behind again. And I think we can move to the next one as well. And the next one. Excellent. Okay. So there are a couple of steps that I think companies can start taking to respond to this suggestion in the memorandum and to be enhancing and improving compliance programs to incorporate these suggestions. I think the first starts with the same place that we always sort of start in compliance, which is with identifying the risk. It's sort of conducting what I sort of view as like a little mini risk assessment, mostly focused on getting information. What applications are people using? What applications can the company preserve? Where's the delta? What are people using that we're not preserving? That sort of information gathering is going to be really important because, as we said previously, the DOJ wants the policies and the program to respond to what's happening in the reality of the company, to respond to what's happening at the company. And so I think that first step is really the information gathering, sort of the assessment piece of this puzzle. And I think there are a couple of different ways that the companies can do that. We're sort of seeing that conducting things like anonymous surveys can often be helpful because that gives you access to a wide range of employees on an anonymous basis. And to the extent that they're responding, you can start to gather information about those applications that people are using. But that's one sort of potential way. That's one potential way of sort of gathering that information that's necessary as a first step and to be able to build a program around the reality. So then that sort of moves us to the second phase, which I view as sort of the company identifying the communication channels that employees can use, sort of making that list. These are the channels that we use for our business, that we allow to be used for our business, that we preserve. So maybe that's Zoom and the chats on Zoom or Microsoft Teams or whatever else, obviously emails, but identifying those really clearly so that that's sort of the genesis of the policy, which comes a little bit later, but at least you're identifying what can be preserved on your systems and really delineating that. Because that also helps to carve out what's not appropriate, what cannot be used. So sort of establishing that baseline of these are the applications that we're preserving and that we're allowing to be used for our business.
Maria, does that mean that companies should start banning employees from using WhatsApp? I mean, that would be an impractical solution, it seems to me, for companies that are operating particularly in Latin America.
So not necessarily, and I think that takes us to some of the other points, some of the other practical steps that we've sort of contemplated. But if employees are using off-channel communications, one thing that we think is going to be increasingly important is to establish some sort of method or mechanism or repository for those off-channel communications to somehow get onto the system. So whether that's requiring employees to sort of forward the business communications to those channels or some other technology that might allow those WhatsApp messages to get onto the company systems for preservation. But that's one of the other sort of steps that we think is going to be really important, so that the company can show that it's doing everything it can to get those communications onto the system. And I think also in terms of sort of the employee side, we've talked a little bit about assessing the risks and identifying the communication channels that can be used. But the natural next step is then, well, let's update our policies and make sure that we're really clear in our policies about what we expect from our employees. And obviously that also comes with a training component and making sure that our employees are aware of what we think can be used for legitimate purposes, what can't be used, and recognizing that to the extent that we're using applications that really shouldn't be used for business, we've set up this mechanism, this possibility to get those communications onto our system.
That doesn't it sort of at the end of the day come down to, from a policy perspective, having very, very clearly drawn lines that if I'm a company who's operating in Latin America and I know my employees use WhatsApp all the time, to have a clear policy that basically says, we're not going to prohibit you from using WhatsApp because, we understand that that's a really fundamental part of how people communicate in their daily lives. But as it relates to communicating about substantive business areas, we expect substantive conversations to take place through platforms that are provided by the company and preserved by the company. So, for example, if you're talking to somebody about, getting together for dinner or, going to have a drink after work, it's not really all that critical for a company to preserve those communications. But if you are talking about that same person about negotiating the commercial terms of a deal, those business related communications should take place on some sort of channel that's being preserved by the company.
That's right. And I think the two sort of other pieces to this puzzle that are very important, given how conscientious individual employees need to be about ensuring that they're using appropriate channels for business communications, in addition to the policy updates and the clarity and the communication about what's acceptable and what's not, and the training, there's also the monitoring piece and the consequences piece. So determining ways to establishing ways to monitor employee conduct, and whether that means requiring certain certifications or sampling company issued devices that have been returned to see what people are actually doing, or if permissible under local laws, doing some sort of sampling of live active devices. Whatever, the monitoring can take different forms, but that monitoring is going to be an important piece, especially at the outset when we're establishing these enhancements to the programs, to ensure that the employees both understand what they're supposed to be doing and are actually following through and complying with the policies. And then the final piece is for those employees that aren't, where it's become clear that they're not following the new guidance, that are not following the requirements under the various policies, and determining what the consequences will be and ensuring that those consequences are consistently applied within the organization.
Maria, it's sort of easier for a company that gives its employees devices, right? If a company issues corporate devices to its employees, if it's small enough or resourced enough to be able to do that, it seems to me it's much easier then to implement some of the guidance here that you're sharing with the group. What about a situation where a company, either, because of resources or for it's just more efficient, decides to adopt a BYOD or a bring your own device policy? How does this play out in the context of a BYOD policy where employees go out and they purchase their own device? And so, they may be communicating about business things. They may have access to their corporate email. They may have a WhatsApp where they're communicating about business issues, but at the same time, they have pictures of their spouse, their kids, they have videos, they have a whole lot of private and personal information that obviously is very, very sensitive and confidential, especially under the data privacy laws that exist in many of the jurisdictions in Latin America. How do companies think about trying to implement this type of guidance in the DOJ memo and sort of make that consistent with a BYOD policy?
So I think in some ways at a conceptual level, some of the steps are similar, but I do think there are some additional considerations to take to, to be mindful of. Um, so in the same way that we're updating policies and we're saying this is what's permissible and what's not permissible, the companies that are using a BYOD or allowing employees to use their own devices for business purposes should also have a BYOD policy that's going to have similar language about what's permissible and what's not permissible. And often, and this is sort of a place where the local laws and those local law implications come into play, there needs to be some sort of consideration of how a company can monitor those exact devices, right, with the personal data and the pictures and the videos. And in some instances under local law, it will be difficult to sort of sample or look at some of that data, but that analysis needs to occur. And I think in some instances where we're using where employees are using their own devices or where there is that BYOD policy, some of those other control mechanisms that we often use in other contexts come into play here. So perhaps it's harder to sample or perhaps it's harder to collect that data. But I think a couple of things need to sort of maybe be considered. Maybe under local law, there's a way to get consent or from the employees to be able to extract some of the business communications and sort of check and look at just the business communications. Or maybe it requires certifications like we do in other contexts to say the employee has certified and understood that they need to be using these channels and that they're not using inappropriate channels for business communications. It's certainly not a perfect system, and it's certainly more of an art than a science at this point. But I think those are steps that a company can take to show that it's trying really hard to respond to the DOJ's suggestions in the memo, while considering local law and local law implications. And I think even in the BYOD context, which admittedly is much harder, and it might be harder to gather that data, taking these steps to clearly articulate what's permissible with your own device, what's not permissible, what they should be doing, what they shouldn't be doing, requiring those certifications, considering consents and whether consents are applicable or usable. All of those steps start to show the effort that I think the DOJ will want to see. And it puts the company in a position to be able to explain or justify, or if necessary, defend its approach to ephemeral messaging in a way that is quite compelling and that I think the DOJ would be receptive to and responsive to.
Great. Maria, we're gonna transition to talking about the second big item that's the sort of new in the DOJ guidance. Before we do that, I just want to take a second. I know we've had a couple of questions, but before we move and start talking about executive compensation, I'd like to see if there are other questions. This is often an area where there's a lot of interest in terms of ephemeral messaging and use of WhatsApp. So maybe give a second to see if other people raise their hand or would like to ask questions before we move to something else. Okay. We've either done a good job of explaining or we've bored people to death. So let's go ahead and let's pivot. The second really significant change in the DOJ's updated memo refers to executive compensation, and sort of how companies should be incentivizing positive compliance conduct through executive compensation mechanisms. And in fact, Maria, you and I talked about this before the call today. There was an article in this morning's Wall Street Journal that deals specifically with this issue. And so maybe give us a sense, if you will, about, what does the memo say with respect to executive compensation and how are we seeing this play out as recently as the article today?
Sure. So this is one of those other concepts that has sort of been in the works and sort of marinating for some time. Previous iterations of this memo had some language or passing language about the need to incentivize compliance with the compliance program or the need to punish and deter um, non-compliance. And there were references to compensation as a tool and a means by which to incentivize or to deter. This version of the memorandum is much more explicit, much more detailed about using compensation structures and using consequences such as clawbacks or recoupment to punish those that have not complied. And so, just in terms of sort of the actual document, there's a whole new section on executive on these compensation structures and these types of issues to really show that the DOJ wants to see use of compensation as a way to do just that, incentivize compliance or to deter those that haven't. And this concept has taken hold very quickly because, as Jeff mentioned, just this morning, there was an article in the Wall Street Journal about an executive who was stripped of $200,000 in stock awards. And the reason why was because this is like an awesome intersection of these two topics, but he deleted text on his personal phone that the company wanted to review. So he did not comply with the provisions under sort of the ephemeral messaging side of all of this. And as a result, he was stripped of $200,000 in stock options. He's an executive. His compensation has a couple of different components, but this shows like very, very clearly when there was a violation of policy, when he didn't preserve text messages that had to do with the business, the consequence was directly tied to his compensation. And we saw it, like, as I said, just this morning, this $200,000 clawback essentially over deleted text messages.
Maria, let me jump in. It seems
Sure.
like, this is an area where, we talked about data privacy considerations when we were talking about the use of WhatsApp. Now we're talking about, sort of really significant labor implications,
Yeah.
right? This is the DOJ in the United States essentially telling companies outside of the United States how they should be treating their executives with respect to compensation. So what does DOJ say in the memo in terms of the intersection between these sort of grandiose pronouncements that they make and local labor implications?
So it's pretty explicit, and they do recognize just that exact tension, that there are local laws and local law implications. And I think in the same way that we talked about sort of that tension that can arise in different contexts, it can certainly arise here too. I think this is an area much like ephemeral messaging that really requires sort of that scrutiny of the local law. What is allowed, what is not allowed. And if this sort of recoupment or this sort of clawback or use of compensation isn't permissible under local law, I think the DOJ recognizes that there are going to be those scenarios, but in the same way that before they said we really want to probe and we really want to understand how the local law is driving your program, I think in this space too, that same analysis is going to be important. Like recognizing that local laws come into play, recognizing that the DOJ can't just come in and say you have to do it this way because there are those local law implications, and recognizing that in this particular space, it's very, very sensitive, particularly in sort of pro-employee countries or countries that have pro-employee laws. This kind of proclaimment isn't possible. But that sort of announcement, that sort of analysis of, okay, what does the local law require? What can we do with the DOJ guidance? Is there a way to reconcile? That analysis, I think, is still going to be very important going forward.
Yeah, and I would just add, historically, and now I'm going to age myself, but going back 10 or 20 years, it used to be the case where you would sit down across from the DOJ or the SEC and you would say, well, we would love to give you those documents, or we would love to make certain people available to you, but we can't because of local data privacy considerations. And more often than not, the US authorities would sort of stand down and say, okay, we understand that there are some impediments there, and you would sort of go on your way and the investigation would continue. that is absolutely far removed from where we are today. That's not to say that DOJ and the SEC, are inclined to ignore the implications of local law, but they are certainly going to require companies to justify in a very, very clear and sometimes painful way why they made certain decisions triggered by local laws that put in tension a compliance program that is, shall we say, less than adherent to the DOJ memo. So, Maria, let's talk a little bit more in detail about what the memo says with respect to executive compensation, and what are the factors that DOJ has articulated in the memo as being key for a company to design its system.
Sure. Next slide, please. So the DOJ memo articulates 5 factors that should be considered and can sort of provide a bit of a roadmap for companies as they're thinking through executive compensation and clawback schemes. The 5 are listed here on the slide are the human resources processes, the disciplinary measures, consistent application of those measures, the financial incentive system, and effectiveness. So I will just briefly mention or sort of touch on those 5. But at sort of their core, these are the 5 factors that should sort of work together to guide a company in determining how to establish a policy or how to establish a program around executive compensation and clawbacks. So again, this often comes up, this idea of clawing back compensation. It often comes up in the disciplinary context. An employee, just as we said earlier, violated policies, didn't preserve text messages, and then had the sort of economic repercussion as a result. So the human resources processes, the first factor in this map, really talks about and really asks whether a company has been transparent in designing and implementing and announcing and explaining its disciplinary decisions. So this isn't so much about how the disciplinary decisions are made, but this is about the transparency in those disciplinary decisions. The second factor on disciplinary measures considers which measures are available. Are there policies and procedures that outline sort of what the disciplinary measures can be at a company, including whether there's a policy or maybe there are several policies and procedures that work together to talk about compensation and how it can be used in the context of sort of recoupment or clawback, as a response to misconduct. So those are the sort of the first 2, and again, we're sort of talking about this in the context of discipline and misconduct and how we're responding to the discipline. But really, there needs to be some consideration sort of from the company side of what factor, what disciplinary actions are available. The third talks about consistent application, and this is something that we've seen in the DOJ memorandum in other spaces, right? There are other parts of the memorandum that talk about incentivizing compliance or punishing compliance or punishing violations or non-compliance. And in that section, there is a discussion about consistency, making sure that these disciplinary measures are applied consistently. And that is true in this context here. This factor essentially tells prosecutors you need to evaluate whether disciplinary actions and incentives are fairly applied across the organization. The CEO doesn't get a free pass just for being the CEO. Someone else in the organization doesn't get punished just because there's someone else in the organization. There needs to be that same consistency for similar types of misconduct. The fourth factor that the DOJ has articulated for companies to consider is specifically called the financial incentive systems. And this factor really focuses on whether the company has considered the impact of financial incentives on compliance. And here, again, we talk about local laws, but here in the memorandum, the DOJ specifically understands and specifically recognizes that local laws might affect the ability to claw back compensation. But this factor, the DOJ, when looking at this factor, might ask or might consider whether there are provisions for clawing back or reducing compensation for compliance violations or for misconduct. Whether those provisions, whether those policies are maintained and enforced and consistent with local laws. And then the final factor is effectiveness. And this factor instructs prosecutors to evaluate how the company has ensured effective consequent management and the quality of the company's investigation. So here the prosecutors are instructed to consider whether compensation is subject to cancellation for ethical violations and how much compensation has been impacted as a result of the compliance activities, whether they're positive or negative. So those are, pretty high level. You can sort of see how they start to work together. But here too, we're starting to think about, okay, how are we responding to misconduct? What are the tools available? How are we using those tools to consistently, and how are we using those tools to ensure that people are following the compliance program? And how are we using those tools? Are we clearly articulating those tools and being transparent about those tools with the company more broadly?
Great. If we can go to the next slide, please. We have one question that was posted to see if the slides will be shared. We're happy to share the slides after the presentation, and certainly if there are specific questions that people have, happy to have a separate conversation following today's presentation. Maria, we're sort of short on time, but let me just quickly mention that together with the guidance that's included in the DOJ memo, the DOJ at the same time has announced a pilot program that basically follows the same guidance in the DOJ memo, but essentially says that for companies that are going to be resolving criminal actions or criminal investigations with DOJ, those companies now will be required as a condition to the settlement with the DOJ to incorporate compliance-related metrics or criteria in their compensation systems. So that's a really sort of significant change, that as a condition to agreeing to a criminal resolution, companies will have to, so this would be mandatory, will have to incorporate compliance-related metrics into their comp systems. And also part of that pilot program essentially gives companies the carrot or the incentive to reduce the fines that they would be charged or assessed by the DOJ by being able to offset or reduce the fines in an amount equal to the compensation that they're able to claw back or recoup from employees who had engaged in misconduct. And so you have the DOJ establishing these new standards in the DOJ memorandum, and at the same time launching this pilot program. So you can see how much of a focus this has been by DOJ. And this is something that is going to continue to be an area of really significant focus as DOJ, again, one of its main priorities being try to hold individuals accountable for misconduct. And this is one of the primary tools that they see as part of that effort. But before we finish, Maria, I think on the executive compensation piece, similar to what we did on ephemeral messaging, I think it would be helpful to talk a little bit about, the practicality of this. What are some of the practical steps that a company should be thinking about as it tries to kind of strike that balance between being responsive to the DOJ guidance, but obviously also wanting to operate consistent with local law?
Sure. So I think the first step is to take a look at the employment agreements of certain executives. And this review of employment agreements might be very telling because it may very well be that there are already clawback clauses or sort of the functional equivalent already included in those agreements. So I sort of view the first sort of practical step as doing that review and analysis and sort of taking stock of what the company already has in place in those executive compensation agreements or those executive employment agreements. The second step that we think is pretty important, especially in this context, is
Let's
to start.
go to the next slide. Sorry. Just
Right.
if we can go to the last slide, please. Thanks.
Is to start talking to local counsel, right? Here's a place where, as the DOJ has noted, and as we've talked about during our time together today, where there could be some tension with the local law. And so before you start writing policies that are consistent with DOJ, suggestions, but that might be at odds with local laws, it's important to sort of take stock and understand where the local law sits and whether this is permissible. This sort of clawback use of compensation in this space is permissible. So we sort of view that sort of local law, local lawyer engagement as a pretty important piece early in this process to establish the boundaries here. And then third, and this will be informed by numbers 1 and 2, but by steps 1 and 2, the third step would be to consider developing a policy that really puts certain categories of employees, and this typically will be more senior employees, on a notice that their compensation can be recouped under certain circumstances. And here, sort of in this policy, I think one of the most important pieces is to make sure that the categories of employees that are going to be subject to this potential clawback need to be very clearly defined. So it needs to be a policy that clearly articulates, here are the employees that might be subject to this, and here's what could happen under these circumstances. But really, the purpose of that policy is to make sure that employees are aware and are on notice of what could happen if they fail to comply with with elements of the compliance program. And then the fourth is sort of a broader step that both deals with sort of collecting data and using that data to sort of identify, okay, how is the company dealing with misconduct? How is that conduct being investigated? What have been the repercussions? Making sure that we're sort of tracking that data within the company. Because that data, the DOJ is going to want to see that data and use that data to sort of start to determine whether or not use of compensation would be appropriate. But in addition to sort of that tracking and data collection in this sort of fourth piece, there's also this idea of using real life examples and incorporating those examples into compliance trainings or into town hall meetings and sort of saying, okay, well, here, just like this morning, there was an executive that didn't preserve text messages. And as a result, these were the consequences. But using those real life examples in trainings so that employees are aware and understand the potential consequences for failing to comply or for engaging in non-compliant behavior.
Okay, Maria, thank you very much. Were you going to say something else?
Well, just the one last piece that I was going to mention, and I know that we've talked to certain clients about this already, but this idea of including compliance metrics in the performance evaluation system. So when you're at the end of the year, when you're looking at your employees and you're saying, okay, this employee was always on time and did really excellent work and is a very good writer and does X, Y, and Z, part of that evaluation might also include sort of this employee was really a compliance champion and was really helpful in setting, an appropriate tone within the organization. And therefore, the promotion is another reason why the promotion is warranted or another reason why the bonus is warranted, but sort of including those metrics in the evaluation program.
Great idea. Let me just give people another minute to, if there are questions either on the ephemeral messaging piece or the executive compensation. What I would say is, we've covered a lot of territory within 60 minutes because we wanted to be conscious of people's time and attention. These are tricky issues. It was tricky when DOJ first issued the memo in 2017, and it has become more complicated, as you can see, with each revision to the memo. And so, we're grateful for the opportunity to talk today, and certainly, available and open to talk on a one-on-one or a small group basis if there are specific questions that people have in terms of how to put some of this into practical effect. So let me just again express our appreciation for everybody taking the time to join, and on behalf of Maria, myself, Miller, Chevalier, and the Compliance Latam team, thank everybody for joining and wish you all a good afternoon. Thank you so much.